construction series platform. Today, we got a good start because we have about 300 participants in the morning today. And the topic for the day is employment and human resources issues. Now, we have two special guests today with us. One, Mr. Donovan Cheah from Mr.Donovan and Ho, and Mr. Rohan Arasoo, who is a partner of Harron Lam Partnership. Now, they will be dealing with issues relating to the options available to the employers during this time of COVID-19 pandemic. How are they going to manage their headcount costs, and at the same time to also maintain their workers as many as possible? And they will also be discussing about whether the subsidy provided by the government is sufficient to keep them afloat. And if not, what are the steps that can actually take to minimize the impact and keep the business running? Now, without further ado, I'm going to invite Donovan to introduce himself. He will be making his presentation first. Thereafter, Rohan will come on the platform where HomeKit will put some questions to him relating to the HR and employment issues. And we will also be taking questions from the floors. So if any one of you who has a question relating to their company, what are the options available, and relating to the law about the employment law, please post your question on the platform, and we will then pose these questions to the special guests after their presentation today. Now, Donovan, over to you.
Right. Thanks, Harold, and thanks everyone for having me. Now, I think Harold's already introduced myself, so I won't talk too much about me. I'll go straight into what we're going to talk about today. And I think many of us as business owners, we are struggling with employment and HR issues, especially not just from COVID-19, but particularly from the movement control order that has been issued by the government, right, since 18th of March, and now it has been extended to 28th of April, and we don't know if it will be extended further. So with the movement control order, many businesses have been required to put a stop to their operations unless they are in essential services. And even those who have been granted permission to operate have to operate under very strict conditions. Now, this normally comes with a lot of employment law and human resources issues, because you end up with situations like your employees not working or working from home, or just simply not being able to perform their functions because of an order by the government. Now, many of you now, I suppose, are in the construction industry, and salary cost is obviously a big component of your overheads, all right? And when you're hiring people like your project managers, your construction workers and whatnot, but they cannot go to the site and they cannot perform their functions, the main issue is, of course, how are you going to support your company's costs if you have to continue paying their salaries, but you are unable to actually progress your project to meet the payment milestone and collect cash, all right? So naturally, it is a very legitimate concern by a lot of employers, not just in the construction industry, but everywhere else. How are they going to manage this cost when on one hand, they are required to stop operations, which means their revenue capability is being impacted. And on the other hand, we are getting information from the government that, you can't cut your employees' salary, you can't put them on paid leave. So how are we going to balance these two requirements? So a very common question that employers ask myself in my area of practice, employment law, all the employers have been coming to us since the MCO has been implemented. And the typical things they want to do is, can they impose pay cuts on their employees? Can they, if they can't do pay cuts, can they put their employees on unpaid leave, whether for a short amount of time or for longer, like 3 to 6 months? Or can they even do things like force employees to go on annual leave? Now, in answering this question, whether can we do these things, okay, we have to look at 2 points. The first point is the commercial aspect, which is commercially, what are your reasons for doing this? Okay, it is understandable that a lot of businesses are looking at these options because, like I mentioned, a majority of your overhead costs will come from staff costs and salary. Now, salary reduction and unpaid leave commercially is an obvious choice for a lot of employers because of their direct impact to your company. Companies are looking at that also. It may not be a direct cost saving when you look at it, when you ask your employees to use up their annual leave, but it is one option for you because some companies will actually provide financial provisions for annual leave balances that have been accrued but not used by the employees because when the employee ends their service, whether due to resignation or termination, you are required to encash their annual leave and pay them a cash equivalent of the amount of leave which they have accrued but not used. So utilizing annual leave during this period, for example, during the MCO period, while not directly cutting your costs, will allow you to free up your annual leave provisions, financial provisions, and use it for other operating costs, and it will reduce the total payout in the event the employee resigns later, or if you touch wood, you have to retrench them or terminate them. Okay, so these are the 3 main ways of trying to cut down your company costs in terms of overhead and salaries. Okay, so the main question now, of course, from a legal aspect is, can this be done? Okay, the Ministry of Human Resources, those of you who have seen the FAQs and the news reports, has stated time and again in all their guidelines and in the FAQ that employers cannot do pay cut, unpaid leave, and forced annual leave unless they get the employee to consent. So what does it mean by consent? Okay, and why do we say that you need to get your employees to agree? So legally, consent is required because when you try to impose these 3 things, pay cut, unpaid leave, and forced annual leave, these are actually amendments to your employment contract. So it is something, if I can do the analogy in the construction industry, it's like a variation order in a way. You're asking the employee to do something different from what you had originally agreed. So you are trying to do a change to their contract because under the contract, you agreed to pay them a certain amount of money, which is their salary. So you can't reduce without getting.
I think Donovan has been cut off for a while. Just bear with us for a minute. I think he will be rejoining very soon. Now, in the meantime, Donovan has actually shared with us about the employment issues, the introduction, the options about unpaid leave, and the pay cuts. Now, okay, Donovan is back, so he will be continuing with his presentation. As you can see that he's trying to start the sharing screen again. Donovan, you are with us?
Yeah.
Okay, you may continue.
So, yeah, can you?
Donovan? Hi, Donovan.
Can you hear me?
Yes.
Yeah.
Can
you
may
hear
proceed
me?
with the presentation? Yes, yes.
Hi, can you hear me?
Yes, yes, we can
Yeah.
hear you, Donovan. Okay. You
All
can
right. Okay.
presentation. Okay.
All right. Okay. So as I was saying, earlier on, you have to do you have to get the consent of your employees when you try to do pay cut, unpaid leave, or forced annual leave, because this is a variation to their employment contract. So legally, from a legal perspective, you have to get consent if you want to do these three things. And there are some organizations, I think, which have issued some statement to pay them during the MCO, because if they are not working and they can't work from home, you have no legal obligation to pay them. Now, I would take those kind of advice with a little bit of a grain of salt. So just be careful. From a legal perspective, so far, our view is that consent is still required. So if you do things and impose unilateral pay cut and unpaid leave on your employees, you could be exposing yourself to a risk of a legal claim. All right. So how should you ask for consent? This is going to be the tricky part. All right, because saying that you need to get consent of your employee is easy, but how are you actually going to get consent? Because this is a very sensitive topic. Okay, so from a legal perspective, again, what we recommend is that employers should always ensure that they get their employees' consent in writing. So it is important to have a record of employee.
I think Donovan is out of the system again. We have to try one more time for him to rejoin. Just 1 minute. I think Donovan is back again. Donovan, can you hear us? Donovan?
Yeah, can you hear me?
Yes, I think there's something wrong with your internet connectivity. Yeah.
Okay, I think I have, my internet looks fine, but now I'll have to go through again very quickly so that we don't, I'll share my screen again.
Yes, please.
Yeah.
Yep, Donovan, you may proceed.
Okay, so I was saying that you should ask for consent in writing, employee to confirm in writing that they've agreed to the options that you have implemented. And before getting the approach in writing, you can have a town hall discussion with your employees to let them know about the economic situation and the measures that you are seeking to implement, so that
Now, Hongkit, whilst we are, I think Donovan may have some technical glitch issues. We can actually go perhaps interview Rohan about the employment issues.
Yeah, of course. So yeah, we have another guest, Rohan, from Header and Lump Partnership. He will be answering some common employment and HR questions today. But before that, I'll let him introduce himself. Rohan, over to you.
Thank you very much, Hongkit. Good morning, ladies and gentlemen. Thank you for taking your time to participate in this session. As mentioned by Loon and Hongkit, I'm with Herald and Lump Partnership. I've been in practice for about 14 years now, and employment law is one of my core areas of practice. And I'm here today to share with you my views and thoughts on some of the common issues faced by both employers and employees due to the implementation of the MCO by the Malaysian government. And before Hongkit proceeds to ask me certain questions, just to echo what Donovan had mentioned, I think it is important, especially for employers during this time, before you decide to implement any measures which may have an impact or which may affect an employee's right, you should get their consent first. So for example, if you wish to impose a salary cut, or if you would like your employees to go on unpaid leave or utilize their annual leave, it is very important for you to get their consent first. I know a lot of employers are facing difficulties, especially those involved in non-essential services, where you cannot operate during the duration of the MCO. It has taken a toll on your business, so you may be tempted to implement such measures. So before you do so, like what Donovan had mentioned, it is important for you to get the consent of the employee. So it's important for both the employer and employees to engage in a dialogue where there is open and transparent communication, so that all these issues can be discussed and a solution can be worked out. Thank you. Back to you, Hong Kit.
Great. Thank you, Rohan. So since Donovan cannot continue his session for now, I think there will be more burden to you to answer our audience today. So let's get started with the questions now. Rohan, during MCO, as we all know by now, only essential services are allowed to continue. Construction does not fall under essential services except those approved as critical activities. How does this affect the construction industry?
Okay, ladies and gentlemen, as most of you would be aware, the Malaysian government, in making the decision to extend the movement control order to phase 3 until the 28th of April 2020, has also come up with a list of sectors which can actually operate during this phase. And one of the industries which have been opened up, which have been allowed to operate, is the construction industry. Certain projects or certain activities relating to construction works can actually operate during this phase 3 of the movement control order. And those of you in the construction industry, where the projects involve G1 and G2 contractors, where the projects have reached physical progress of about 90%, those of you involved in tunneling works, maintenance works, sloping works, or cleaning of stagnant water, spraying of pesticide, and also works which are left incomplete would pose a danger. And in fact, the government has also allowed certain professionals like architects, engineers, quantity surveyors, project managers, amongst others, to operate during this phase. But of course, in order for these industries to operate, including the construction industry, you must first submit an application to MITI. And this application can be submitted online at MITI's website. And I'm sure many of you who are in these listed sectors would have already submitted your applications by now. Some of you may have already gotten approval to operate. So just bear in mind, you can only commence operations upon approval having been granted by MITI. And for those of you in the construction industry, it's also important to remember that if you're involved in several projects, you will need to file an application separately for each project. Or if you're operating from various or multiple project sites, you would also need to file in an application and seek approval for each site separately. Now, in the event approval is granted for you to operate during this phase 3 of the MCO, there are very stringent conditions or standard operating procedures which you need to comply with. And these SOPs may vary from industry to industry. And for example, if you're allowed to operate during this phase 3, there may be restrictions in terms of the number of employees who can operate. You may be only allowed to operate with a maximum of 50% of your workforce. There may also be limitations in terms of the number of working hours or working days. You may be allowed to only work, say for example, 3 times a week, and say from 10 a.m. to 4 p.m. And I know this would potentially pose some problems or some challenges to these industries. Like for example, the construction industry, where time it's a very important factor. Time is the essence of most construction contracts. So if you are required to work with a reduced workforce or reduced working hours, it may affect your progress of the works. But these are, of course, separate considerations. From an employment perspective, if you get approval, yes, you can operate, but you just need to be mindful of these conditions that are imposed by the government or other relevant authorities. And besides which, you also need to adhere to strict health and safety protocols. For example, you must ensure that you have adequate hand sanitizers placed at your premises. You must ensure that all your employees wear a face mask while they are at work. And you also need to have a thermometer in place. You need to record the readings of all your employees who are present at work. And you also need to have an SOP in place for your employees, for your workforce, so as to ensure that all your employees are aware of this health and safety requirements that need to be complied with. And this is very important because MITI in their recent FAQ has stated that if employers fail to comply with these conditions, not only can the approval be revoked, but employers could also be liable under the relevant act. It could be a criminal offense, and employers could be subjected to a fine or even imprisonment. So you just need to be very careful with this. And if you're allowed to operate, you need to carry out proper planning. You can also perhaps consider having a rotation system to decide which employees go in on which day. All these are things that you need to look out for. And just before I hand it back to Hongkit, some of you may also have this question in mind. Say, for example, you're allowed to operate during this phase 3. You have gotten approval from MITI. What happens if, say, one of your employees refuses to show up at work because of fear of contracting the virus? Well, what I would say is this. So long as you have obtained approval from MITI to operate, and your employee has already, your employee's name has already been approved by MITI to return to work and to carry out business, I think it would be fair and reasonable for an employer to expect the employee to attend work. And if the employee refuses to attend work without any valid reason, then the employer may take whatever steps necessary as provided under the employment contract. This may also include disciplinary proceedings if the situation merits such action being taken. Thank you.
Rohan, you mentioned the application is made based on project. So if you have multiple projects, then you have to make multiple applications. But who is supposed to make the application? Is it the main contractor or employer, or each subcontractor has to make their own application?
Okay. Insofar as making the application is concerned, if you're talking about the construction industry, it is the main contractor who has to make the application first. And only if the main contractor's application is approved by MITI can the subcontractor then go ahead and make an application. If, for example, the main contractor's application is rejected by MITI, then the subcontractor cannot file an application, because naturally the subcontractor cannot file an application, because naturally the subcontractor will not be able to proceed with the works if the main contractor itself cannot proceed with the works. Thank you.
Okay, thank you, Rohan. I'm moving on to my second question. So most of the companies are not operating at all during MCO, and this means no business, no income. In this circumstance, can an employer rely on force majeure or frustration to terminate an employment contract?
Okay, I'm sure many of you would have heard of the term force majeure and frustration. This is an issue that has cropped up consistently during this MCO period. And of course, those of you in the construction industry will be familiar with the term force majeure, because most standard forms of contract contain this provision. Dealing with the issue of force majeure, on whether an employer can rely on a force majeure provision. Of course, firstly, it depends on whether the employment contract contains a force majeure provision. Of course, if the employment contract does not contain a force majeure provision, then of course the employer cannot rely on force majeure and the employer may look to frustration. But if, say for example, your employment contract contains a force majeure provision, then you will need to look into the wordings of the force majeure provision. Does the force majeure provision cover events like a pandemic or governmental action? If the force majeure provision does not cover such events, then the employer naturally cannot rely on the force majeure clause. Now, if the force majeure clause in the contract contains events like pandemics such as the COVID-19 or governmental action such as the MCO implemented by the Malaysian government, then there are other considerations that will need to be looked into as well. Are there any other conditions that need to be fulfilled by the employer? For example, is there a notice requirement? Must the employer give advance notice to the employee before relying on the force majeure provision? And then another important consideration is whether the employment contract allows the employee to terminate the employment contract based on the force majeure event, or can the employer only terminate the contract if the force majeure event prolongs for a certain period of time? Say, for example, only if the force majeure event prolongs for 60 days can the employer terminate. Or maybe the employment contract may only entitle the employer to suspend payment, for example. It may provide the employer with an option of suspending payment during the period of the force majeure event. And one other important aspect that needs to be looked into is whether there's a duty on the part of the employer to mitigate, to take alternative steps. And like most of us are aware now, with the advancement of technology, a lot of work can actually be done from home or at remote areas. Employees need not be physically present in office to get the job done. So if an employee is able to work from home, like for example, the legal industry, many of us lawyers are actually able to work from home. That's what most of us are doing currently. So force majeure may not be a right provision to rely on because you're not prevented from performing your contractual obligations. You can only rely on force majeure if you're actually totally prevented from performing your contractual obligations. If you can actually get work done, maybe not at full capacity, then you cannot rely on force majeure. So what I would say to employers is that you have to be very careful when you decide to exercise your right under a force majeure clause. It is best avoided if you ask me. And now coming to the issue of frustration. Frustration is of course provided under our Contracts Act, section 57. And the doctrine of frustration does apply to employment contracts in certain circumstances. Now, does the COVID-19 or the implementation of the MCO give rise to the doctrine of frustration? Can an employer terminate the contract based on frustration? I wouldn't say so. I would say no. And the reason why I say no is this. Because in order for you to rely on frustration, the event or circumstances must render it impossible or unlawful for you to perform your contractual obligations. Now, yes, if you're an employer or employee in non-essential services and you're not allowed to operate during the movement control order, yes, you cannot be physically be present at your office premises to carry out works. But you can still, as I said, carry out work from home. There are other alternative steps that you can do to get work done. So in my view, the movement control order merely makes it more difficult for you to work. It makes it more onerous for employees and employees to get the job done, but it does not make it impossible for work to be done. And in fact, the Human Resource Ministry, in one of their recent FAQs, have stated that employers cannot rely on the doctrine of frustration because the MCO is only for a temporary period. Once the MCO is uplifted, employees and employees can go back to business as usual. And in fact, now where more industries have been allowed to operate during phase 3, it would negate the right of the parties to actually rely on the doctrine of frustration. So just to sum up, Hong Kit, on this issue, I would say I would advise that parties be very careful if they wish to rely on force majeure or frustration. And if you're an employer, you are not sure whether you can exercise this right, I think it is best for you to seek legal advice first before you take the necessary steps. Thank you.
Clear, Rohan. What about employees currently on sick leave and maternity leave during the MCO period? How does the employment law deal with that?
Okay, if you're talking about maternity leave, say for example, you have an employee who's currently on maternity leave, and this maternity leave period overlaps with the MCO period. This would actually not affect the employee's right to her maternity leave. She is still entitled to her maternity leave for the duration as prescribed in a contract or as decided by her employer. Many companies now allow their employees who are on maternity leave to go on leave for a period of 3 months. Some allow them to go for a period of 60 days. So this would not affect your right. And insofar as employees who are on sick leave, okay, if you are, say for example, you're an employer in essential services and you can operate during the MCO, and one of your employees falls sick, you then of course cannot compel your employee to report to work. Or even if you're in non-essential services, you are not operating from your business premises, you cannot require your employee to work from home if the employee is on sick leave. You can make appropriate deductions based on your employment contract for the sick leave period. Yeah, so the MCO would not have any adverse effect on maternity leave or sick leave, Hong Kit.
Okay. Rohan, what are the remedies available to an employee if his employer violates the employment law during this period? What can he do?
Okay, insofar as remedies are concerned, there are several remedies available to employees. If you're an employee falling within the purview of the Employment Act 1955, employees whose salaries range between 2,000 ringgit to 5,000 ringgit per month would fall within the purview of the Employment Act 1955. So if you're an employee and you're faced with a situation where your employer has imposed, say for example, a pay cut during this MCO period without your agreement, without your consent, you may then file a complaint to the Labour Department. And the Labour Department will then carry out the necessary investigations. And if an employer is found guilty under the Act for not abiding by its contractual obligations, an employer can actually be fined under the Act up to a maximum of 10,000 ringgit. If you're an employee whose salary is more than 5,000 ringgit and you fall within the purview of the Industrial Relations Act 1967, then if you're faced with a situation where the employer does not comply with its contractual obligations, you may lodge a complaint to the Industrial Relations Department. And in fact, if you have been laid off or your services have been terminated during this MCO period, an employee may potentially make a written representation to the Industrial Relations Department for constructive dismissal. But of course, in order to do so, an employee needs to satisfy certain requirements, one of which there must be a breach of the employment contract by the employer. The breach must go to the root of the contract, as in it must be a fundamental breach. For example, if your salary is not paid during the MCO period, that's a fundamental breach. If you are terminated without justification, that's a fundamental breach. Another obligation on the employee is that the employee must inform the employer and must give the employer an opportunity to remedy this breach. And fourthly, the employee must leave this employment because of this breach. It cannot be a situation where the employee has left the employment because the employee has obtained a better offer elsewhere. and then the employee decides to go and file a claim for unfair dismissal or constructive dismissal against the employer. That will not work. And if the representation is successfully made to the Industrial Relations Department, and the representation is eventually referred to the Industrial Court, the Industrial Court, in deciding the dispute, may either reinstate the employee to his or her former position and order back wages, or alternatively, the Industrial Court may grant the employee compensation in lieu of reinstatement, as well as back wages. Besides this, if there's a situation where, for example, your employer compels you to come into work, although you're involved in non-essential services and you cannot operate during this movement control order, the Human Resource Ministry in the FAQ has stated that the employee can actually lodge a report to either the police or to RELA. In fact, the police and RELA have been the designated authorities, the approved authorities under the Act. So if you're faced with such a situation, you can lodge a complaint. And just one final point, Hongkit, if you're an employee who is faced with a layoff, you have been laid off by your employer because of this movement control order, and you fall within the purview of the Employment Act, you would also be entitled to termination and layoff benefits. It is prescribed in the regulations, subject to you at least having served the company for a period of 1 year. There is a scale, and you would be entitled to termination benefit. And if you are not an employee falling within the purview of the Employment Act, you may still be entitled to some benefits depending on the terms of your employment contract. Yeah, that would be.
Thank you, Rohan. I will now pass the mic back to Wailun. Wailun, over to you.
Yeah, thank you, Rohan and Hongkit, for filling up the time and the questions from the floor, relating to employment issues while Donovan was away. Now, Donovan, are you back here again with us?
Yeah, I'm back.
Okay, hi, Donovan. Unfortunate that the audience would not be able to view your presentation earlier, but I understand that you only wanted to give an overview as to what can be done and what cannot be done during this period of time. You have mentioned that when it comes to unpaid, forced unpaid leave, pay cards, all these need to get the consent from the employees before the employers can actually do so. Now, one of the questions that was posed by the audience is this: if the nature of the job, right, requires the employees to be physically present at the work site, and because they are not essential services and the employees cannot be physically present at the work site, can they deduct salaries or force them to take unpaid leave or deduct from the annual leave in such a circumstance?
All right, in such a circumstance, actually there is no difference between whether the employee is physically able to work from home or they need to be physically present at the office or the site. So the employment law principle as it stands is that if you want to cut salary or put them on unpaid leave, you still need consent. This is because it's not a situation where the employee is refusing to work or refusing to render the service. It is a situation where they are willing and able, it's just that they are not able to due to the MCO period. So the current position is that even if your workers cannot do anything at home and they are essentially on like a paid holiday, you still have to get their consent if you want to reduce the salary or put them on a unpaid leave system. If not, there is some risk that the employee could come after the employer for the things that Rohan has mentioned earlier.
I see. So in the meantime, you're saying is that the employee is willing and able to do so. It's just that the circumstances prevented them from doing so. Yeah. And at the same time, because this MCO is temporary in nature, the employer cannot rely on the doctrine of frustration to say that the employment contract is frustrated because it's only temporary in nature. So in such a situation, that means the employers are actually left with very few options in order to reduce the cost of the headcounts without the consent of the employees. Am I correct?
Yeah, so I would say that the options are quite, if you want to talk about a risk-free option or a low-risk option, it's quite limited simply because of how our employment law landscape has been set up and also the position that has been taken by the Ministry of Human Resources. So speaking just purely from an employee management perspective, okay, getting employees to consent is actually the best way that you can implement these cost-cutting measures. And what is important, therefore, for employers to think about is employee communication, because in my line of work, I've seen actually many companies that have implemented it, and they actually have been successful in getting all their employees to consent to these measures. It really depends a lot on how you communicate the situation with the
Some
employees.
specific instance, Donovan, you said that there have been, quite a number of successes whereby the employers managed to communicate with their employees and get their consent on either the pay cuts or the forced annual leave or unpaid leave during the MCO period, right? So is there any specific instance? And I want to also know, right, the instance that you're going to share with us, right, does it also include an element of implied threats?
Yeah. All right. Okay. Yeah, it's a very, a thin line that we have to walk. Okay, and we have to balance it very carefully. But the success stories that I've seen, actually, the one that I can think of is in the construction industry. Is a fit out company. So what they do is they did have a lot of town hall sessions with the employees. They meet all the employees. I think now because of MCO, it's like video conference or whatnot. And they do a lot of communication regularly to let them know what is the financial position of the company, what is the status of things going on, and they even share things like this is how much cash runway we have that will last us if we don't manage to collect payment soon. So they actually share and they're very transparent with the employees, like this is how much we have left to survive if we don't take some drastic measure right now. So we need your cooperation, all of you, if you can agree to this, let's say a reduction of your pay, or some even do things like salary deferment, we pay you your salary a bit later. If you can support us on this will actually help us preserve our cash runway. It will protect job security for a lot of you, because if you don't agree to it, that's fine. That's your prerogative. That's your choice. But it may mean that we have to look at more severe options such as downsizing, which could affect a lot more employees. So of course, the way you say it can be viewed as if an employee is being difficult, they can say that's a threat, because if you're telling me that I don't accept this pay cut, all of us are going to get fired. So it is really a matter of how you convey that. If you can convince the employees that doing this now is actually a very good long-term benefit for them, then it's not really an issue of threat anymore. It is the employees making an informed decision to accept a salary cut to protect their job in the long term. So in those kind of situations, I think the trend that I see is that if your company has actually always had a very good relationship with your employees and you have always had that good culture of communication, it becomes very easy at this stage. Your success rate for consent is high. But if you are the type that previously don't communicate with the employees, not very transparent, don't give them the right information, then you may have to prepare yourself for a tougher uphill task if you want to convince them to support you in this initiative. So it is now the time when you really test how much trust you have built in your employees.
That's very true, Donovan.
Yeah.
Now, I have also a question from the floor. Let's say if the employees agree to a pay cut or a forced annual leave during the MCO, can this thing be reinstated, or once the MCO is lifted? Or is it going to be a permanent foregoing of rights by the employees?
I would say it's actually up to you and what you tell them at the start. Normally, I would recommend if you're going to propose a pay cut or unpaid leave, you should inform the employees that it will be reviewed when the situation changes, because I think it's only fair as well that if you are putting a pay cut because of the current situation now, should the situation change, you should commit to your employees that this will no longer be applicable. So what I've seen some clients do as well is that they say, we will review it or revisit this again in, let's say, 3 months. And if the situation change, we will update you. If not, it will continue until further notice. So you give at least some indication to the employees that this is not a complete foregoing of rights. It is just to help us keep the business afloat during this very difficult period where we actually cannot generate revenue.
I see. Now, Donovan, we have actually seen situations where an employee says negative things about their employer on social media due to cost-cutting measures.
Yeah.
Some employees even upload their company's internal memos on the cost-cutting measures that they have implemented. You know, what can or should an employer do in such a circumstance?
Yeah, this is now, you know, the age of internet, everything is online, right? Everybody has social media and all that. And I don't know if any of you have seen, there have been cases of employees, they even write like on Twitter to their state representatives, the politicians, and then they go and tag the Minister of Human Resources, and they will say that, oh, my company forced me to do a pay cut and they forced me to go on annual leave. Then they share even like the internal letters, like, you know, from the company to the employees. So we've had clients as well who have faced a situation. And the difficult part is, of course, the PR issue. Whether it's legal or not, what you've done, of course, depends on how you've communicated to the employees. But when it goes on the internet, it is a reputational issue, because typically it will be one side of the story. The employee will usually say that the employer has breached the law, and then they will ask for people to take action against them. And on the consumer side, if you are, you know, your business is dealing with consumers, there's that issue of people will say boycott, or let's, you know, punish them. So it could affect your business. So from a legal perspective, what the employee has done is technically a breach of confidence, because internal documentation is typically confidential information. So when an employee uploads that to the public without employer's consent, that is a breach of their employment contract. Legal action can be taken against them. You can get things like an injunction to restrain them from publishing further or making defamatory comments. You can even sue them for damages if you can show that there's a direct loss caused by their actions. However, that is just the legal part. Practically speaking, again, companies have to evaluate, do you want to take legal action against your employee during this period when the public sentiment is already skewed against employers, where the public views that employees should be protected. So practically, most employers are not going to go to that stage where they go and issue like a injunction against the employee, incur the cost. Already times are bad, they're not going to incur legal fees, and they're not going to suffer the bad press of, you know, being coming out on newspaper for suing their employee. So in such situations, what I normally recommend clients to deal with is that they should focus a lot on the PR side. If there is wrong allegations made about them in the media or on social media, they should definitely work on, you know, a crisis communication thing where they clarify the allegations, give their version of events, and then internally you can deal with the issue through disciplinary process of the employee for violating either the employee policy about confidential information or for causing damage to the company. So you can put them through a disciplinary process, and they can even be dismissed for misconduct if they have done something completely like in bad faith, out to damage the company, spread lies for the company on social media. All that are permissible grounds to terminate them as well. So we normally recommend you resolve that issue internally, but externally you work on salvaging your reputation through issuing your own statements and clarifying any wrong allegations that have been made. Thank you.
I see. Donovan, I got a very interesting question from the floor. I do not know whether you are able to answer it on an impromptu basis, but perhaps
Okay.
I think
I'll
accept that all these questions require some detailed research, perhaps. Now, this came from one person called Dennis Lim.
Okay.
He or she is actually from a theme park industry. Now,
Okay.
they are actually closing down offices and wish to transfer their staff to park general crew. Now, and that is to keep their original salary. But and they give the options to these officer staff. If the officer staff refuse to be transferred and keep their original salary, then they have the option to resign. Now, can they actually do that? you either be transferred or resign.
Yeah, okay. I get the general theme of what they're trying to do, but I would say, I will put it this way, you shouldn't be giving option to the employee to do something or resign. Okay, in the current situation that you've mentioned, theme park industry, if the staff is no longer able to perform their work because all the theme park and the offices have closed down, there's nothing left for them to do. It means their role is redundant. So that means you no longer require these employees. So what you should be telling the employees is, look, we have to close down our office and parks. We're no longer performing this kind of role anymore. So your role is redundant. You are surplus to the company. However, we have an option for you to continue working with us, but it's going to be a different job scope. Okay, this is the role that we have. It is the same salary, but it's something different than what you're doing. It is free for you to accept it if you want to. But of course, if you don't accept it, you have to acknowledge the fact that you're already redundant and you will be retrenched because we just don't need the role anymore. So it is not a situation where you ask the employee to resign because the role isn't there anymore. You have to terminate them, whether they accept the transfer or not. Okay, that you have to terminate them.
Actually, the other way of looking at it is like you're already redundant, you will be retrenched, but I'm trying to help you to give you another job scope. If you want to take it, then you will continue with us, but if not, then you will remain redundant and you will be retrenched eventually. Correct. And that's legal as well, right?
Correct.
I have another question for you, Donovan. It's getting very interesting actually, because you see, there are actually some ideas of SMEs, even micro businesses, whereby they say that, you know, during this point in time, no point that I want to continue with my business. Like for example, if I'm operating a steamboat restaurant, right? Even if the MO is lifted, I don't think a lot of people will be visiting that. And you'll be continuing to pay rent, especially when the employer only give a waiver of rent or reduce the rent only for a period of time. And you would think that because of the high cost operation and the business will become not viable anymore. But you just want to close it down now and you wish to open it, let's say 1 year later. You know, what would you advise to the employees in such a situation?
Yeah, closure of business is legally permissible. Okay, if you weigh everything and you realize that commercially it doesn't make any sense for you to continue or even try to continue during this period, there is nothing wrong with you closing your business and terminating all your employees because you are not running a business anymore. So that is fine as long as it is justified commercially. You have good reasons. It is not going to be an issue from a legal perspective. The second issue is more of if you want to reopen. Okay, like if let's say things really turn around in a short term or even let's say in 1 year and you want to reopen, again, there's actually nothing wrong with you reopening. It's just that the question is, of course, if you have a chance to reopen, the general fair labor practice that is recommended is that you should go back to the employees that you terminated earlier and reoffer them employment because you are now ready to start again and you have vacancies available. So as a fair industrial practice, it is recommended, not mandatory by law, but highly recommended that you at least reach out to the staff that you discharged earlier and offer them the same roles back again, or even if it's something semi-related role, do offer them employment again because it may be relevant later if there's a dispute about whether your closure was bona fide at the start.
I see. Donovan, you see, after hearing from you and Rohan, it appears to me that without the consent of the employees, right, there is actually very little room for the employer to maneuver in order for them to reduce the headcount costs, right? So I just want to ask you, what other cost-cutting measures can employers implement in such a situation?
Yeah, so of course, the major ones that we covered earlier are the key ones, but there are also other ways which you can try to cut costs. So for employee benefits, normally you can look at things like suspending or even removing non-material fringe benefits. Okay, so this typically you will not require consent if it's not a material term of their contract. So this would be things like the very nice to have privileges that you give to your employees. You know, some of you may offer like things like gym membership, lifestyle allowance, clothing allowance, all this, we would call it unnecessary or just like a plus point. You can consider suspending it or removing it. These fringe benefits can be removed. Another thing is if you have things like discretionary bonus and increment, if it's not guaranteed in the contract, For example, like you say that every year I may give you a bonus subject to company's performance and your own performance. That is discretionary. It's not guaranteed. You can look at removing it or giving it, reducing it to zero or a very low amount, especially if your bonus time is coming up soon. So you may not be legally obliged to give them any bonus. So that's one way to cut costs. Same thing, you should freeze your increment. Definitely, internally freeze headcount. Those of you who have the EA employees, like Rohan has mentioned and classified, obviously reduce the overtime. Make sure that any overtime has to be approved in advance, because you also don't want these employees like dragging their feet and then purposely being slow, and then they incur the overtime, and then you have to pay overtime, which will increase your cost. So you should also look at maybe issuing like a firm-wide policy that employees are no longer required to work overtime. So any overtime you do has to be approved in advance before we will let you work overtime. So that is one way to cut your costs. Then the usual is looking for cheaper suppliers, cheaper service providers, cheaper materials, all that you have to do. But I think on your point earlier, just go back quickly about, there not being much that we can do if employees don't consent. I think that is true, but the thing we also have to remember is that companies can make a decision. Do they want to still push ahead and do something for cost cutting even without the employees' consent? There is the legal risk, like I mentioned, but I think employers should also weigh whether the risk is practical, whether it will actually happen. Because in this current situation, employees also may not necessarily go to the extent of suing the company because you cut their pay by 20%. If you recall what Rohan said earlier, for these employees to sue you, they have to quit. They have to say that I protest, you have cut my pay by 20%, you have breached my contract, so I have no choice but to quit. Only then they are entitled to sue you for constructive dismissal. So when you weigh the issue really carefully, you have to make the judgment call. Are your employees going to quit and lose their job security simply because you cut the 20%, or are they just going to really just complain about it and then kind of wait and see for a few months and see whether things improve? And if the risk of them, your employees are not the argumentative type, not the very difficult type, realistically, it could be that none of the employees will actually take the action to sue. So you have to weigh that and see whether this is something that you can still implement if you're comfortable enough in terms of taking the risk appetite. So that's, I think, is something that employers really need to think about in this era.
I see, understand. Donovan, there's another question from the floor.
Yeah.
You understand about the subsidies given by the government,
yeah.
For salaries for employees, the 4,000 and below. Let's say the employer gets the benefits of the subsidies. In respect of these employees, can the employer still go and negotiate for a salary reduction with this group of employees that is subsidized by the government?
So quick answer, no. Once you apply for and get the subsidy, you cannot retrench these employees, and you cannot give any salary cut to these employees for a period of 3 months, which is the 3 months you will get your wage subsidy, and an additional 3 months after. So you have to be very careful when you think about applying for this wage subsidy, because you are essentially binding yourself for 6 months, and you are fixing your costs for these employees for 6 months at a minimum. So if you do a calculation, please check whether the subsidy is going to help you or not. Because if you're only going to get like a low subsidy and you only have 5 to 10 employees who may qualify for this subsidy, overall, maybe it may not be worth it for you to just collect that 800 to 1,200 ringgit a month. And then later on, you're stuck for 6 months and you cannot do anything to these employees. So I think you need to do a financial evaluation and cost analysis before you actually apply for the subsidy.
I see. There are actually many questions coming in, even at this point in time, after the session has overrun for more than half an hour. I think we'll just take the last question from the floor. It just says that can the employee reduce salary selectively and not across the board? I think it's quite obvious, the answer, right?
Of course, subject to consent, there's no issue if you choose to have different rates apply to different people, or even have it for certain classes of people. So quite common, we've seen the higher level employees like management will normally be subject to a higher percentage of cut, like maybe sometimes up to 50% because they're earning more. And some companies will choose that those who are lower income, either they're exempt from salary reduction because they're already earning a low amount, or they will get a smaller cut. But just to remember, to remind everyone here that if you do this salary reduction, even with consent, you have to ensure that you don't drop below the minimum wage. So under Malaysia, we have a minimum wage law. For monthly salary, it's 1,200 ringgit a month. If you do a salary cut, you have to make sure that it doesn't drop below that amount. Because even if the employee consents, it is still a violation of the law if you drop below 1,200. So it is also quite possible selectively those employees who are already lower income or close to 1,200, you don't cut their salary because they're going to end up below the minimum wage.
Wow, thanks, Donovan. Yeah. Really, thanks a lot for the sharing, because all these issues are really pertinent. I'm sure you have answered most of the questions that the audience have today, because I have actually picked up many questions from the chat room where the participants have actually posed questions. Now, before we end the session, because you dropped off in the very beginning, now can you just perhaps summarize what are the things that you wanted to say which you have not said until now?
Right, I think if I can just very quickly recap what I was going to do in the presentation is, number one, just make sure that if you are planning to implement salary cut and unpaid leave or forced annual leave, get employees' consent. Number two, if you don't get the employee's consent or you cannot get the employee's consent, make a risk assessment whether you are prepared to still push through with your measure because it is necessary for you to save your business, or the other option is that you don't implement the measures to those people who objected. Okay, but that's going to be viewed as possibly unfair to those people who cooperated with you. So weigh those options very carefully. Thirdly, retrenchment is possible if it is really physically impossible for you to do anything else. It's a last resort. Let's say your employees are not agreeing with you on all your cost-saving proposals, nothing else is working. Retrenchment is perfectly legal, provided you have good commercial grounds to do it, and you are not hiding a hidden agenda to get rid of like certain employees and then using retrenchment as an excuse. So as long as you have good commercial reasons and you follow the right process, retrenchment is fine even during MCO and even during the COVID-19 outbreak. So don't worry about that. Just make sure you comply with the law when you actually do the exercise. So I think these are the main issues that I wanted to cover, and the wage subsidy issues are actually in the slide. All the details are in the slides, and I believe you'll be sharing with the audience after this session. So
yes,
those
definitely.
are my closing remarks. Yeah.
We will be sharing the slides to all the audience. And I think despite that you have been dropped off at the or you dropped off at the very beginning, I think we have covered all the points that we wanted to say and share with the audience today. Am I correct, Donovan?
Yeah, I think that is it. But of course, I think my slides have my contact details. If anybody has any questions, feel free to drop me an email. If there's a specific matter which you need some time for us to discuss, then please let me know.
Yep, thank you very much, Donovan. And Rohan, do you have any else that you would like to comment on arising from Donovan's answers?
Thank you, Wailun. I think just as a closing remark, and just to echo what Donovan has said, I think in times like this, what is very important is for there to be open communication, open and transparent communication between employers and employees. You see, we all are in a situation where it's neither the fault of the employer or the employee. And I know a lot of employers are going through financial difficulties because there's no business, they cannot operate. And likewise, if you look at it from an employee's perspective, it is not a situation where they don't want to go to work, they just cannot go to work. So I think a lot of the issues being faced by employers and employees can possibly be resolved if there is open communication between employer and employee. So if you're an employer, you want to implement certain measures, I think it's good if you can sit down with your employees, have a transparent discussion with them, and work out a proper solution. And of course, if you're not sure of what to do, what steps to take, then it may be advisable for employers to seek appropriate legal advice, even employees likewise. Yeah, I think that's what I would have to say as a closing remark, Wailun.
Okay, thank you, Rohan. Donovan, do you have any closing remark for our audience today?
Yeah, I think I really echo what Rohan has said. Now is really the time where you demonstrate how good is your employee relationships and your employee communication. And these people are really going to be the make or break part of your business right now, because if they don't cooperate, you are going to face a lot of legal hurdles. But if they really support you in this matter, things can go a lot more smoothly, especially when it comes to the difficulties arising from the MCO.
Thank you, Donovan. You know what? I know audience and also Donovan and Rohan. This is one of the most well-received topic, and we have received so many comments from the floor and also the audience, and we have been bombarded with a lot of questions asking Donovan to repeat the presentations again. No, I tell you what. In view of the session that is so well received, and we receive a lot of support from our audience, and depending on what the audience have got to say, if they really want to see Donovan and Rohan again, we can do a rerun. That would actually depends on how the audience think, and we can actually give a wider tweak to the topic today and discuss more issues that are being faced by the employers and the employees at this difficult moment. Now, again, I would like to thank both Donovan Cheah and also Rohan Arasoo for taking the time to share their views and also to answer questions from the floor. And I hope that the audience actually enjoyed this session despite the initial technical glitch that we have encountered. And thank you for your patience. Thank you very much, everyone. Hongkit, I will pass the mic over to you to close the session.
Yeah, thank you, Wailun. Thank you, Donovan and Rohan, for your time. Though there was some connection problem earlier, I believe the audience still be able to benefit a lot from the Q&A session. So another timely sharing, as these are the pressing issues faced by all the businesses today. As Donovan and Rohan have said, this is a really unique situation, so everybody should work hand in hand rather than standing their ground. Also, I think forcing employees to pay full salary is not the best, nor the only solution, and it could be disastrous in the future. Businesses may just as well give up and call it a day. So personally, I'm more inclined to explore a creative approach, such as cost rationalization exercise on fixed overhead costs to ensure the employees continue to be paid. And hopefully, everyone working together, we may soon see an end to the COVID-19 crisis. Now, to be creative, our mind has to challenge the current structure and to think outside the box and also see outside the country, which we will do tomorrow. We are honored to have 3 loyal friends from Singapore, Yi Hong, Spring, and Jun Yu, to share with us an overview of the Singapore COVID-19 Temporary Measure Act. Although this act does not apply to us in Malaysia, but we still can get an overview on how our neighbor country is dealing with the COVID-19 crisis, and from there, draw inspiration to formulate some creative solutions to our own problems. So yeah, please continue to support us. Thank you all. Enjoy the rest of your day. Thank you, Wailun. Thank you, Rohan. Thank you, Donovan.
Thank you, everyone. Yeah, have a good day ahead.
Yes, bye.